in court on October 31st, 2023, where the defendant pled guilty to count 1 of the indictment, failure to comply, a felony of the 3rd degree, in violation of revised code, section 2921.331B. The defendant was found guilty and the court ordered a pre-sentence investigation and report. The state has had the opportunity to review that report and is prepared to proceed with sentencing. Thank you.
Thank you. Mr. Hinton, any reason not to go forward with sentencing?
No such reason, Your Honor.
Anything you want to say on behalf of your client?
Yes, I would, Your Honor. I'd indicate that I had a chance to speak with Ms. Taylor about some of the items that came about in the pre-sentence report, and we spent a lot of time talking about the mental health issues, and she's been very upfront as far as the gambling addiction. Also indicated and emphasized the diagnosis for bipolar, and indicated she has a lot of anxiety. And I bring this up because I believe that this had a role in what happened in this situation. Now, Ms. Taylor indicates that, as she was being pulled over, she initially stopped, and she was asked to get out of the vehicle, wasn't given a reason why, and something just went off in her head. She didn't feel right. I'm not saying that this is a defense that she was insane at the time of the offense or anything of that nature, but offering this as an explanation for mitigation as to why this may have occurred, but something didn't seem right to her, and that's why she took off. And where I'm going with this is that I think community control sanctions would be appropriate, being that this is a felony of the 3rd degree. I understand there's not a presumption for community control or a presumption against, but I think that based on the fact that although she has a criminal history, it does date back. I think there's certainly a number of years of her being a law-abiding citizen. I know during the pendency of this case, she was working, she was employed, and the way she earned income was driving. So the mandatory license suspension is certainly going to be quite a bit in the way of punishment for her. That she received credit for the 3 days that she did in this case, and that no further residential sanctions be issued, but that, again, that the court puts a large emphasis as to the various conditions of probation on mental health. Thank you.
Thank you. Ms. Taylor, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say at this time?
Hello, Judge Culotta. I just wanted to say pretty much that I do apologize to the courts for anything I did in the past period and, present. And I just wanted to say that I would definitely think that you guys wouldn't be mad at giving me, if I was to get probation, because I would definitely be doing everything I have to do, I'm not one that, some monster you need to keep off the street. I just wanted to tell you guys that, trust me. If anything, I want to help people, and that's what I dedicate my life to doing for the most part, And it's so crazy because even before I came here, I'm all rustling around, you guys, because I had stuff that I was helping people with, whether it be my cousin had a fire and I had to take her some things, I was like, let me do all this. I'm supposed to be focused on myself, getting here, and I'm trying to get these guys. Somebody was like, girl, is you crazy? I'm like, no, I got to get them their stuff because I don't know what's going to happen today, if I'm going to be able to help them when I leave here. If I leave here, you know what I'm saying? So I say all that to say that you would be doing a good thing if you give me probation or whatever you can do so that I don't have to spend any time away from my kids or the community, because I'm not one that's out here in this community just, doing stuff that I shouldn't be doing, and you know what I'm saying? So I just thought I wanted to tell you guys that much, so you can see, hey, you'll be doing something good if you do that. Trust me, you won't see me back in this courtroom. You never see me here in Lake County anyway, but you definitely won't. I want to go out and help people and let them know that this isn't the way, And I have somebody I had talked to, and it's crazy, I met him literally 2 days ago at the laundromat. He said that's what he does, and he's gonna have something starting up in January where he's gonna be talking to kids and stuff. And I'm like, what? I wanted to do that, go into like the justice places and, talk to kids and let them know this isn't what you wanna do, and that I came a long way getting my CDL and everything, and they can do it too. But, that's all, Judge Culotta. I just wanted to let you know, I definitely apologize, and I'm not just sitting here just making stuff up as I go. I'm just letting you know how I feel, from the bottom of my heart. I really apologize to you guys.
Thank you. Mr. Hinton, anything else?
Your Honor, I would just incorporate the various letters that were written on Ms. Taylor's behalf and provided to the state and the court.
Thank you. Ms. Hronik, the State of Ohio.
Thank you, Your Honor. Generally, in a case where we have a defendant that does have a prior failure to comply conviction, especially a defendant who went to prison for that conviction, the state would be recommending a prison term. However, the prior offense was 22 years ago. The defendant has been living a law-abiding life since that time, so the state is going to recommend community control at this time. However, the specific facts of the incident were very dangerous for the officer, who had begun to open the door, whose hand was on the door, and his body was between the door and the vehicle when the defendant took off on the highway. And in addition to that factor, while both of the defendant's drug screens were negative, she did have traces of cocaine in her system on both of those screens, which means she was using while on bond. So based on the danger to the officer and that fact, the state is going to request that the court impose a local jail term. Thank you.
This court did review the pre-sentence report and investigation and considered the facts and circumstances of the offense involved, the nature of the offense involved. I've considered what's been said here this afternoon by Mr. Hinton, Ms. Taylor herself, the prosecutor, the recommendations from everybody. I did receive several letters from family members and acquaintances of Ms. Taylor's, and I've read those and considered those. I consider all of this in light of the purposes and principles of felony sentencing, which are set forth in 29-29-11 of the revised code. As for the factors in 29-29-12, factors indicating the conduct is more or less serious, the court notes specifically two things. One, that while the pursuit was short in terms of the distance and period of time, the defendant did initially accelerate. She was over 100 miles an hour when she takes off. And she also, at the time that she fled, one of the officers at the scene was at her door, hand on the door, in a position which put him at a risk of serious physical harm as a result of the defendant's conduct. When she took off with him in that position, she's lucky. She's very, very lucky that he wasn't seriously injured as a result. Those are factors indicating it's more serious. Again, the speed involved and the fact that she did this with the officer in the position he was in when she chose to flee. Nothing makes it, well, I will say no for the less serious, that the chase, the pursuit was short. Now, it was short because the police called it off. It wasn't because she stopped. So I guess that really doesn't make it less serious because it wasn't anything that she did to make it less serious. The police just called it off after a very short period of time. As for recidivism factors, the court notes the defendant does have a prior history of criminal convictions. Goes back some time, 27 years or so is when it first started. The first two times that she was convicted, she actually was sent to prison, so she served 2 prison sentences for 3 separate cases. The second prison stint, I believe, was for 2 separate cases that were run concurrent with each other. The last time, though, was, I think, early 2000s. But she did, again, previously serve a prison term, and it does have a history of criminal convictions. As for factors indicating recidivism is less likely, the court does note that the defendant did lead a law-abiding life for a significant number of years while she had those issues 20 years ago. Basically, for the last 20 years, there's nothing here except I think there's a disorderly conduct and some curfew violation, if I'm remembering correctly.
Oh. Forgot about that. Oh, goodness. The
Um,
curfew.
So the court does note that for the less serious factors. This is a felony of the third degree. There's no presumption for probation or prison. Normally in these cases, courts are inclined to send someone to prison, and in particular, as the prosecutor noted, when a person's been to prison twice before for 3 cases, it's almost a foregone conclusion. But again, I note that the time period between the last one, so I'm not going to impose a prison term at this time. I'll find prisons not consistent with the purposes and principles of sentencing. And the defendant is amenable to an available community control sanction, so I'm going to place the defendant on community control sanctions for a period of 2 years. However, with this type of conduct, there does need to be consequences. The court's going to order the defendant to serve 60 days in the Lake County Jail. She has credit for 3 days. I'm going to order that during the last 30 days, she enter and complete the jail treatment program if accepted after assessment, and if accepted, successfully complete that program and follow all aftercare recommendations. I'm going to further order the defendant not use any drugs or alcohol. That includes anything. No gummies, no marijuana, no medical marijuana, nothing.
I don't like none of that stuff.
Well, yeah, you do. You said you did.
I don't.
Well, you told probation you did. You have traces of cocaine in your
Okay.
system, so we're not going to argue.
No.
You're not to use any drugs or alcohol.
Okay.
You're not to, you're to submit random urine screens. They have to be negative. A positive screen will result in your probation being terminated.
Okay.
You're not to tamper with urine screens, bring in fake urine, bring in someone else's urine.
No.
Nothing like that. I want you to obtain a mental health evaluation with a special emphasis on gambling addiction, and get whatever counseling or treatment they believe would be beneficial for you to help you with that. Along with whatever other, if there's other mental health issues for counseling or treatment, whatever they recommend, you need to follow those recommendations.
Okay.
You're to only have one treating doctor and dentist. If you have a specialist, that's fine too, but only one treating doctor or dentist that can prescribe you medicine. Probation needs to know who those doctors are. Again, if there's a specialist, let them know. You can only get prescriptions from those doctors, nobody else. You can only get them filled at one pharmacy, and they need to know where that pharmacy is as well. You're to sign whatever releases they need, so if they need to talk to any of those doctors, they can do that. If you're prescribed any type of medication for mental health issues, you need to take that as prescribed. Here, court costs and supervision fees. There is a mandatory license suspension of 3 years to life. I'll do it for the minimum 3 years. Anything else that I'm missing here I should be considering? Ms. Taylor, you understand all the conditions of your probation?
Yes, and as long as I can get something on paper, that's a lot for me to remember, but
Probation you'll get the conditions, plus the rules of probation will be reviewed with you. You'll get all that.
okay. Can I ask you something?
Yes?
I don't know how this goes, but I wanted to ask you, with me having my kids and you saying I got to do 60 days, I have no problem with whatever I got to do. But I just wanted to ask you if I can have the opportunity of getting my kids somewhere where they can be kept for 60 days.
That should have been done. You were coming here today for sentencing, where you could have gone to prison for 3 years. That's what this period of time was for.
I'm begging you. I don't care if it's a day or two. I just need to be able to get them where they got to get to, and then I promise you don't have to worry about me not coming back doing 60 days.
I'm not worried about it, because if I did it,
Okay.
you'd be going
Thank
to prison for an escape charge.
Okay. Thank you so much.
Well, I haven't done anything yet.
Okay. If I go 60 days, I know
I will allow you to report Monday morning. What date is that? Make sure we're all on the same page. December 18th, this Monday, December 18th, you need to report by 9 a.m.
Okay.
That's a condition of your probation.
Okay.
So if you don't do it, your probation will be violated.
I'm doing it.
And I promise you, if you don't show up for that, you're going to prison for 3 years.
I'm doing it.
All right.
I would be a fool not
So
to.
the bond will be continued until, actually, no, bonds will be released. It's a condition of her probation, so I don't care about bond. Condition of your probation is that you report Monday morning, December 18th by 9 a.m.
Okay,
Failure to do that's a violation of your probation.
okay.
I will release bond, and that can be done, you know, in this entry. We don't need to continue until Monday.
Thank you.
Do you have any other questions?
No.
You understand that, what's gonna happen if you don't show up?
Mhm.
All right. Mr. Hinton, anything else?
Nothing further.
I
Your
do
Honor.
need to advise you for the record, if you fail to comply with any of the conditions I've just ordered, any of the rules of probation, which they're gonna go over with you, if you leave Ohio without permission from this court, or if you commit another crime from this day forward, a motion to terminate your probation will be filed. If it's found that you violated, I could extend your probation up to 5 years, I could impose more restrictive sanctions, which could include local jail time, or I could terminate or end your probation and send you to prison. If I sent you to prison, it would be for 36 months in prison, and that could be consecutive to any other prison term you may be serving at that time, if that happened to be the case.
Okay. I just appreciate the 2 years probation, because I know
All
I
right,
could've
well,
got, I was expecting
you
if I
said-
would've got
you
it
said-
longer.
You said, quote, and I'm writing this down, "You will never see me back in this courtroom." So I'm gonna hold you to that. Now, if you wanna come here in 2 years and 1 day and say hello, that's fine, but I'm not planning on seeing you in 2 years then.
Okay.
Hang on, let me just make sure I cover everything. You don't need anything for now, do you,
Only question I have is, the driver's license suspension starts now,
Yes,
correct?
yes. You need to be there by 9 o'clock Monday
Okay.
morning, not
Okay.
9:15 like you were here today. You were late today.
A few minutes, yeah.
Well, no, I don't care if
Okay.
it's a few minutes or 1 minute. If you're not there by 9 o'clock, they're gonna be calling my bailiff, and there's gonna be a warrant issue for you.
So that means I need to be there probably at 8 something.
Well, you can make that decision, but whatever arrangements you need to get here, you better make sure there's not gonna be any excuses that you didn't have transportation, that something happened. So I'm just make sure we're clear on that.
Mhm.
All right. All right, anything else?
No, Your Honor.
Thank
Thank you.
Thank